All right. Thank you everyone for joining us today. Today we're going to be discussing whether you can claim mental distress when you're filing a long-term disability lawsuit. We've gotten this question quite a bit recently, and it is a fairly common thing for people to do to claim mental distress, but certain conditions have to be met. So David put together a presentation today, and he's going to go through that and just kind of outline those different conditions, what it would look like to claim mental distress, how much you can claim, different things like that. So with the mental distress, you're going to be claiming that on top of any benefits you owe, or you can also claim some other damages like punitive damages, aggravated damages. We are just talking about it. There's so many different damages that it can get a little bit confusing, but we're just going to talk about mental distress today.
Excellent. If anyone wants to know why I have a chair right here, it's for my dog. Just so you know. All right, let's dive into this. Gotta get the bit too much sun coming through. Okay, mental distress damages. This is an interesting one for me because this came about the main case in Canada that goes over this happened when I was in law school, and then it went through all the courts of appeal and everything. And so this was a very important case just when was in law school. And then it came up once I was out of law school, I think in the they went to the Supreme Court of Canada and they ruled on it when I was probably like 1 or 2 years into my working as a lawyer. So very interesting. Certainly, it's been a controversial area in the past, but it's very ironed out now. Let's look at it. So I want to start by just giving you an overview of where mental distress damages fits within the bigger picture of damages for long-term disability claims. And damages, when we use that word, that's a legal word just to say compensation. Damages is what a court can award or give to people for compensation at court. And so when I use the word damages, just think compensation, payment that a court would give you. Now, there are two overarching types of compensation that you can get in a long-term disability claim. The first one being contractual damages, this one right here, and the second one being extra contractual. So just quickly, contractual. This is what is paid under your long-term disability policy. So this would be your long-term disability benefits. Waiver of premium benefits would be the other type. I won't get into the details of this, but just know that those are the two types of benefits that you can get under the contract itself. So if the court was to enforce the contract, that's what would be paid. Historically, like dating way back in the law, there was a time where you couldn't get damages outside of the contract in a contract dispute. So courts were limited to giving you what you could get from the contract itself. But there did come a time many years ago in England, where a lot of our law comes from, that courts started awarding something called aggravated damages in contract cases. Surprisingly enough, these were like vacation type cases. So these first started coming up where people would book with a travel agent way back to go on some vacation, and then the contract, or wedding cases as well. So you would book something with a wedding or vacation, and the contract would ended up being not upheld. And so the court started looking at, well, there's more of a loss here than just not getting to go on your vacation. There's the disappointment and all these types of things. So there was a point where courts started awarding aggravated damages on top of any contractual damages in just contract cases. Again, they were these early cases with vacations and weddings and this type of stuff. That trickled around, and over time that just sort of spread out, and it moved to other types of contracts like employment contracts, contracts like long-term disability insurance policies. So aggravated damages were something that um, would were starting to be paid over time. And at a certain point, I won't go into all the details of it, but the Supreme Court of Canada had a case where they switched it from being aggravated damages to just calling it mental distress damages in the context of a long-term disability case, just to avoid confusion. But you will see these two terms conflated. Just read them to really be the same thing, essentially, for a long-term disability case. But you'll still see courts conflating them. Um, but generally, well, not generally, like they literally are the same thing. The mental distress is what the Supreme Court of Canada kind of, that's how they kind of talked about it. And that's the way we like to talk about it. Now, the other types of extra contractual damages are punitive damages. You often hear that thrown around, and consequential damages. Consequential damages would be things that would be other financial losses you've suffered because of kind of a wrongful termination. So think of things like you had to sell your house at a loss because of financial distress. So you've lost money on a forced sale of a house, for example. That could be a type of consequential loss. You can get those kinds of losses if you can prove them. And so they are still something not found within the contract itself. Today, we're going to focus on mental distress damages. Let's go to the next slide here. So again, it's important because these two things get conflated all the time, mental distress damages and punitive damages. They are not the same thing. Courts will conflate them, lawyers will conflate them. Certainly, people who are involved in these cases will kind of conflate them. It's important to know that they are very different. Mental distress damages and also aggravated damages, if you see that term, they are awarded to compensate a person for a loss caused by another. So you are awarded these damages if some other person or business has caused you to suffer a loss. So when someone has to pay aggravated or mental distress damages, they're paying back somebody for something that the person lost because of something they did. Punitive damages are very different from a kind of conceptual point of view. They have nothing to do with a loss that has been suffered. They are simply a punishment for bad behavior. So if the behavior is bad, you don't even have to have lost anything. If the behavior is bad and it's worthy of punishment, then the punishment is paid as a fine. Now, it's unique in that with these kind of court cases where you're suing an insurance company, it is a fine that's paid, but you get the money rather than the fine going to like the government or some other organization. Like the fine is paid, but it goes to you. And punitive damages are reserved for when there has been bad faith behavior that rises to a very high level. So it's not just any bad faith, it would be at a very high level that has to be very malicious and things like that. Very difficult to get punitive damages in Canada. Very, very difficult. Much easier in the US. And so it is important to just keep that in mind. Mental distress does not require there to be bad faith behavior, for first of all. That's often something people think, but it doesn't. So for mental distress damages, you can have those can be paid even though there's been no bad faith behavior by the insurer. You just have to have suffered mental distress because of because they terminated the contract inappropriately, basically, even if they didn't do it in bad faith. So mental distress damages, just to go into a little deeper here, SCC just means Supreme Court of Canada. It's the Fiddler case, if you ever want to look it up. It's a very famous decision. This is the case that finally kind of ruled here's how mental distress damages work in Canada. It's based on this idea of that long-term disability insurance is a form of a peace of mind contract. So part of what you are getting when you get long-term disability benefits, yes, you are getting a contract to be paid you're going to be paid like monthly payments, but the contract is also what you're buying is a peace of mind, knowing that if you are unable to work, you're buying the peace of mind that you will have these benefits coming in to help you if you're no longer able to work because of disability. So an insurer that wrongfully does not pay benefits will basically take away from you your peace of mind, and that is what the mental distress is meant to compensate you for. So with these cases for mental distress, you have to prove there was a breach of the contract that caused a negative impact on your peace of mind. Okay? And there does not have to be any malicious or bad faith behavior by the insurer, which is very important because a lot of people think that that has to be there, but it does not. So the insurer does not have to act in bad faith. They can just, as long as they were wrong, maybe they acted in good faith, but they were wrong. And if they were wrong and it did cause you to suffer a negative impact on your peace of mind, then you can get some level of damages. Now, okay, before I jump into examples, the amount of damages you get will just depend on how serious the impact his mental distress is. I've had cases where I had to tell the client, look, like you're independently wealthy. They did terminate your benefits. It has had no impact on you at all. We can't claim mental distress damages. Like there is no peace of mind loss because you don't even need these benefits. You're independently wealthy. There's no real claim here. No, it's not to say that there couldn't have been a claim there, but there just was not. Like there was no distress over it in terms of losing a peace of mind. Let's look at some cases. So there have been a number of cases in Canada, and I'll just go through some of them here. This case here was one where 10,000 was given for mental distress for there was you have to read these cases to see like what was really going on, but it was sloppy claims handling that was not malicious. There was no punitive damages. So they were given it did result in the benefits being denied for a short period of time, and so the person was awarded $10,000 for mental distress, basically. This Branco case is one of the more famous ones in Canada because it was a huge decision when it first came out that got whittled down through appeals. So what happens with some of these cases is a trial judge or jury will give this massive award of like millions of dollars. Then as it goes through appeals, that damage amount gets whittled down. And this is one of those cases. So I forget how much it started out at, but it ended up at 45,000 for mental distress. I think it was like hundreds of thousands before it got whittled down. So the courts whittled it down. This one went to the Supreme Court of Canada, I believe. In the end, it was $45,000 for mental distress, and it related to a breach of the contract around terminating benefits. From what I could tell, the guy lost his home and had a marriage breakdown were some of the key features. So those were things they looked at to give this higher amount than maybe the 10,000, where there was a period of like inconvenience, but it was a shorter period. This one was more significant, and the person lost his home, had a marriage breakdown that the court accepted was contributed to by the fact that he lost the benefits when there was the wrongful termination. This one here, this is an interesting case. I actually attended court. I was I knew the lawyer that was doing this case in Nova Scotia. This is a Nova Scotia case. I knew the lawyer, so I just went to court. I was interested in the case just to watch some of it. It was pretty wild. This is the highest amount that has been yet given in Canada that has been upheld by courts of appeal, 90,000. So this is the high water mark for mental distress damages. This case was extreme. So just to give you, like, I was shocked even how bad this case was when I was sitting in the trial, like watching it. But they there were a lot of punitive damages too. So this is a case like you'll see these higher amounts, like Branco as well. There were punitive damages in this case. So when there are punitive damages, usually you are going to see higher mental distress damages awarded as well because there's just usually more bad stuff going on that leads to more distress and things like that. So that is why you're seeing such a difference between this 45 and 10. This Bryn case was so, the facts were so absurd. One of the things that was alleged at the trial, and I'd have to reread the judgment, but I'm pretty sure the judge accepted it, was the insurer kept sending statements to Revenue Canada, or the way they were putting the damages into the T4, whatever they were doing, they were intentionally or at least negligently causing Revenue Canada to assess it as taxable income when it wasn't. And this guy, I think, had to go to one or two tax court appeals over it, which was expensive. And they finally had an agreement that they would now do it correctly. And then they did it wrong again. And he was again under Revenue Canada. So he was under multiple Revenue Canada investigations, tax court appeals over the tax issues. And so he ended up having bankruptcy. So it was a very severe situation. So it's going to be very hard for someone else to get to this level of mental distress damages. This is the high watermark, and this was a very extreme situation. Okay, so some more recent examples. We've got this Goodwin case. That one was an interesting one. So I can't recall if there were punitive damages in that case. I think there might have been, but it was 30,000 in 2018, and it really revolved around the idea that there was poor claim handling practices, and it involved also an IME report that the court determined was biased. So that'll perk up a lot of people's ears on here because everyone doesn't want to go to these biased IME. So the court did conclude that it was a biased IME and that the insurer shouldn't relied on it or should have questioned it more or given more information to the IME person. So they really got burned. This is a case where the insurance company got burned for relying on a biased IME. or at least an IME that was, I don't know if they really found it was biased. Maybe biased is not the right word. I think they found the IME was incomplete, that the doctor doing the IME had incomplete information and they did nothing to try to correct it and just relied on this report. So maybe biased is not the right word here. It was a inadequate IME because of improper information and lack of information, and they didn't do anything to correct it. They were just happy to rely on it, and they got burned by the 30,000 for mental distress damages, and I believe punitive damages as well. This next one here, this Greg case, you can see kind of a theme here with Desjardins. So they got dinged again in 2019, 50,000, which is quite high. Again, you don't usually get this high. I'll show you the range in the end here, but 50,000, very high. So this was another extreme case. I think it was in BC, where the mental distress was quite significant, and they had one of the features the judge pointed to when giving this higher award was they let a lost their house and had to, or apartment or whatever, and had to live in their minivan for 6 weeks. So that was something that the judge really looked at, like having to disrupt your life for living in your minivan for 6 weeks was a significant amount of mental distress that needed to be compensated, and that's why you're seeing this award of 50. So again, like the 6 weeks of living in a minivan was not seen as severe as what this Bryn guy went through. Okay, just so you know. Um, but it's still quite, unless you're doing the minivan life and got your minivan YouTube channel, then this is quite a disruption for people to have to go through. And then this Baker case, this is one maybe some people on here have heard about. It's a famous recent case out of Ontario where a jury gave a massive award against an insurer that was upheld on appeal. It's one that a lot of lawyers who work in this area now on our side who are suing insurers will point to this case as a like this is really a bad case for the insurance companies. We had our own case that settled soon after the Court of Appeal upheld the damage awards in this case. We had a case that was similar, um, involved a lot of the same people. I can't really say much beyond that, but that case ended up settling largely because this case got upheld, in my opinion. The other side didn't admit that, but that's what I felt. So in Baker and Blue Cross, there was 40,000 for mental distress. And the facts of that case, so it was a wrongful termination, and there was a lot of mental distress and financial distress. And there was also this element of like excessive surveillance. I think that definitely was in the minds of the that was in the minds of the jury when they awarded this, I'm sure, was the excessive surveillance and just the surveillance was just way over the top. They were surveilling, this person was a grandmother, they were surveilling her with their grandchildren and all these. So a lot of this stuff there was a massive punitive damages. So, but just the loss of peace of mind of having the benefits and the disruption to this person's life, this is where you got this higher award of 40,000. So just to summarize, the range you can get for mental distress damages in these cases is somewhere between 0 and 90. 0 is a common number in these cases because you won't be able to prove it's not given in every case. And with most awards are going to be between 10 and 3. That should say 30,000. So it should be 10 and 30,000, not 3,000. That would be the normal range where most of these cases are going to see the court award somewhere between 10 and 30,000. With some of these exceptional cases going 40, 50, 90 is the highest. There's only ever been 190. And I think there's maybe been one. Let me see here. Well, I'll tell you, since I have it written down here, since 2000, the amounts, these are all the cases in Canada since 2000. There's been 10,000, 10,000, 10,000, 15,000, 25,000, two 30,000s, and the 90,000, which was the Bren case. So that kind of gives you an idea of recently where these cases have gone that have gone to court. So there's been three 10,000s, one 15,000, one 25,000, two 30,000s. Yeah. So that gives you a rough idea. And let me see here. Yep. So if people have questions, I'm happy to answer them. Just keep in mind that these are not damages that insurers are going to willingly pay. So in fact, they will staunchly say they will not pay these damages outside of a judge ordering them to. So there's been many a case that kind of gets held up because clients want compensation for this and the insurers are not offering it. Now, a lot of these cases will just settle for an all inclusive sum that is not really broken down. And the fact, if there are risks on the insurer that they will pay punitive or mental distress damages, it will result in them paying more as a lump sum settlement than they otherwise would. So it does affect the overall settlement, but it's not going to be a line item in there that they're willing to negotiate. So just keep that in mind. I have had cases where basically they have paid these kind of damages, but they've not really admitted to it. So they've just, but based on the compensation they're paying, it does. The only rationale would be that they are including this idea of this kind of money, but they're just saying they're paying to get rid of the lawsuit. They're not going to acknowledge that they paid these kind of damages. You have to be careful. So some people really get their courts will reject if you like a common thing that can happen is cases can move along to a certain point and then insurers will get new information and they will approve the claim. You have to be careful of just going forward to a trial only going after aggravated or punitive damages or mental distress damages. Sorry. Some courts will really push back on that. Now, in other cases, if you have a strong case, they will still award. You can still go to court over just those things, and they will potentially you can get money for them. But I did have in my own just personal experience, I did have a client where that was kind of the situation, and the judge was not very happy with the person wanting to press forward, and was quite blunt with them at a pre-trial settlement conference, basically. So that judge would not have, that person would have got zero if they went forward with that judge. That judge was not wanting to hear it. They didn't feel there was mental distress damages were warranted in the case and didn't want them going forward. The case ended up settling, but that was just so you know, like some judges will push back on this. So it's not willy-nilly that just because your benefits have been denied that you are going to get this compensation in every case, although it's possible. Like you do have to show that there was some mental distress or negative impact on your life. You have to be able to prove that there was something. Um, but some people have a hard job proving that because there's no doctor's record saying that you're under any stress. Like it's very hard to prove in some cases. So just keep that in mind. All righty. I'll leave it there, Maddie, and we can take people's comments and questions on that, or we can talk about any other issue people have.
Yep, let's get started. We got a question here. This one's for me. Hi, Maddie. I'm looking for the webinar replays for January 6th or January 13th, 2022, specifically the one where David goes over yearly update forms. Yeah, so basically with this, I wasn't working at Resolute Legal during this time. I went and looked on our website that we host all of our recordings on, and I can't find any of those. I think the process was back then where you got rid of all the webinars for that year and just did the year moving forward. Um,
We've
I can
covered
do
that
a,
topic many times.
yeah, there's definitely lots of other webinars on that, but I can go look around and see, but I can't find them anywhere on the website that we host everything on.
Okay. Well, that person's going way back in the archives.
Yeah, this person may actually like some of our more recent webinars on update forms may even be
Better.
a
Yeah.
little bit better.
Yeah.
I don't know what year it would have been, but we did have one where we went through a ton of update forms, like actual update forms,
Yeah.
and did lots of examples. So that would be a good one to look at.
All right. See what else we have for questions.
Check our YouTube channel, see if we get any in there. I was denied CPP disability in 2022. Is it too late to reapply?
Well, it depends on what where you were denied. So if you were just denied, if you didn't go to the tribunal hearing and get a final decision, then you can reapply. If you went and got a tribunal decision denying your benefits, then you cannot reapply. So you can reapply. It's not easy to do with when you're applying for the same thing that's already been denied. You can expect to be denied again, but you can win these cases. Sometimes people just didn't follow through with it because they weren't well or for whatever reason. You can reapply. It's important in these cases to get a copy of your old application because when you file the new one, you don't want to have conflicting information because you're still applying for the same period of disability as the first one would have been. If you haven't been back to work since 2022, then you still have to prove your claim based in the past to whenever you'll have to prove that you were disabled as of whatever date you still were covered under CPP. And so that's a very important thing to figure out is when were you covered up to? And basically your new application should be very consistent with your old one unless there's good reasons to change things. So you definitely would want to see your old application when you're doing the new one.
Just a letter from them. Doctor didn't support my application, said I could do something.
Okay. Well, that's still going to be a problem for you because it doesn't matter that you have to prove that you were disabled back then. And even if your doctor is saying you're disabled now, it won't, your doctor would have to change their opinion and say, yeah, they're disabled now. And I think I've changed my mind. I think they were disabled back then as well. So that is what's going to happen. So you can apply again, but you're going to be stuck with that old evidence. So it doesn't matter that maybe you're more disabled now. You'd still have to be able to prove that way back in 2012 or earlier that you were disabled then and continuous till now. So this is why these cases can be quite tricky. I had another lawyer reach out to me for a consultation with one of their clients, and it involved one of these situations that um, where somebody was wondering they got approved for this CPP, but they wondered could they go back further because they didn't apply as early as they could have. What the thing with CPP disability, if you're like this person who we just talked to, who you're doing a late application, the benefits can only go back a year from the date of your that they receive your application. So what happens is you can miss out on past years where you would have been eligible to get the CPP. Some people want to know, can I go back further than a year? And I had a consultation with another lawyer and their client. I basically told them, no, not in your situation. In theory, you can. I have won one case, maybe two, one that I know for sure. It was a massive case, very like shocked even me, but we did win it. Like the benefits paid out were over $200,000, which is unheard of in a CPP case. But it went back 10 years. But that involved a person who was homeless on the streets of a major city in Canada for all that period of time. And it actually had passed away by the time this case got to court. So, but we were still focused on whether that person had the mental capacity to form the intention to apply for CPP disability. And it ended up like we reappealed the case. First, the tribunal said no, they had the capacity, and then we appealed it. And during the appeals, based on I got involved only in the appeals, so the person lost the case. Then they got me involved for the appeals. During the appeals, we got the Service Canada to change their mind, which is pretty unusual, and they agreed to approve it, which was pretty interesting. But in that case, they did accept that the person in question did not have the capacity, the ability to even form the intention to apply. So that's what you look at in these cases. If you ever wonder, could I have gone back further? It's such a hard thing to prove. You have to prove that you didn't have the mental capacity to form the intention to apply. That's a very hard thing to prove. You basically have to be delusional, like like really in a psychosis, or be in a coma. Because even if you're fully paralyzed, but you have your full mind, you would be able to form the intention to apply. Even if you physically couldn't do it yourself, you just have to be able to form the intention to apply and then ask others to help you. It really has to be a situation where you are such a mental state that you can't that you can't. But that was interesting. So they just wanted to know. I told them basically not going to happen in this situation. You would have had the ability. Your mental capacity wasn't that bad. It was very the person was suffering from depression and they definitely were compromised and a brain injury. So it was not like it was a totally frivolous thing to think about, but it wasn't severe enough that I think they would have been successful. Because they were at the time in question, they were applying for other benefits. Their family was applying for other benefits. So it just that there just took away the whole case.
Mhm. The insurer stopped my benefits for an incomplete file. One of my physicians left the clinic and stopped practicing, and I had difficulty getting a copy of my file summary sent to the insurance company. I was also being insured for a separate condition where they have all the information available. Since they don't pay benefits for two separate conditions, I don't think the missing document for condition two should affect my benefits. Would this be eligible for damages?
Okay, I just got to read this one over again. Sure, for a second. Hmm. It's difficult to say. It definitely is one that you should be appealing and have a lawyer look it over because it sounds like they stopped your whenever they stop your benefits, like you should be thinking of appealing and getting legal help. In this case, it sounds like some of your conditions are not covered, is what it looks like you're saying here, since they don't pay benefits for two separate conditions. I don't know what that means. You can benefits are paid based not on conditions, medical conditions, it's based on overall disability, and overall disability can encompass more than one medical condition. Certainly, it's more complicated when you have more than one medical condition. So, I'd encourage you to reach out to us or another firm to get some legal advice. And what they would need to see is your denial letter, the most recent denial letter you got, and any other denial letters that you got sent. And you should do it quickly because I don't know the deadlines you might be under, but just reach out for some help.
All right, we have a question over here on YouTube. Currently on Sun Life and applying for CPP disability, worried they will use vacations I took against me. Is this common?
Yeah, vacations definitely can be used against you. So it's like there's a few red hot issues for LTD insurers and like pregnancy, a spouse retiring, you're close to retirement age is another one, and vacations are a huge one. So vacations definitely are something that you have to be careful of. A lot of it depends on the context and when. So like vacations are really not a good idea if you are just going off work and applying. Not a good time to be taking a vacation. It just looks just a terrible look. You really have to be focused on like doing your treatment and everything. You shouldn't, first thing you should be doing when you're applying for LTD is going on a vacation. I would tell you that's a very bad idea. But if you just took vacations and after the fact, like you're already in treatment, your doctor has okayed it, it's it's fine. The thing with vacations is sometimes people will present an unrealistic, like they'll post photos like everyone does, and maybe you're posting photos that depict your lifestyle in an unrealistic way, and it can look like you're active on vacation, you're climbing mountains, like I famously had a client who had pictures in which she went to Vegas and they went to the Grand Canyon and had pictures of her literally looking like she's hanging her feet off the side of the Grand Canyon. So the insurer was all in arms, but it was an optical illusion. Like she literally was not. But the way the picture is set up, it looks it's a famous picture that people take there. It looks like you're hanging off the edge, but really you're not. But so the insurer was quite upset about that, and then I had to like show, okay, here's a picture from another angle. Like it's not what you think it is. But again, like it will feed the idea that you are much more capable than you are. But you can push back on that. Everyone understands, especially judges will understand that even people on disability need vacation, that just because you can do a vacation doesn't mean you can work on a regular basis. So I wouldn't be too concerned. I'd be more worried about Sun Life using vacations against you or any other insurer than I would CPP. CPP is going to be more focused on they will be focused on whether because they'll be more focused on whether you have tried enough alternate employments to prove that you can't do something else. To be approved by an LTD, you can still be capable of working at a level that CPP would require you. So they will, they will, CPP will be really concerned about whether you are capable of working in some other job and if you've tried hard enough to look at other jobs. And if you are, hopefully you'll be able to get help. So if you're at an insurer like Sun Life and you're applying for CPP, hopefully they will be able to hook you up with advocates who work with some of these LTD insurers to represent people in these cases. We know of one group called, oh boy, what are they called?
Disability
Yes,
advocacy group.
DCAs. Yeah. They work with a lot of insurers. They're a very high quality group. I would highly recommend them. So if your insurer is hooking you up with the Disability Advocacy Claims Clinic, DCAC, then you are in good hands. So a lot of people worry that if the insurer is recommending someone that it just could be biased or like not looking out for your best interest. That's it's not really necessarily true because it is in the insurer's interest to get you approved for CPP. Um, Now, it's true that if someone is being paid by the insurer, like maybe they have some allegiances to the insurer, but ultimately those kind of things, kind of conflicts can come up and it's not necessarily bad or wrong. And certainly, I can't speak for all these groups, but I do know the disability claims advocacy, they are definitely have their heart in the right place, and I would highly recommend them.
While we wait for more questions, I actually have a question.
Yep.
What is the difference between general damages and aggravated damages? Because it seems like they can kind of overlap.
Yes. Oh boy, you're gonna get me on the spot here. So general damages are going to be something there's the it depends on the area that you're in, whether you're in a contract or whether you're into negligence. But for example, general damages will be in negligence type cases, so a car accident injury type cases. General damages are ones that can't be calculated with specifically. So like for example, if you are owed money that can be calculated, like you're owed this debt, you can show it. That is like considered like a special damage.
Hmm.
Whereas general damages are something that can't be quantified easily, and so they are awarded. So like future income loss would be a very common general damage.
Hmm.
And the the that is basically how you would have to try to figure it out. There's not a way to calculate it with precision, so there's going to be more estimates and these types of things.
Hmm. Yeah, it's confusing. Like even for everyone listening, we're working on an article right now. We should have that up shortly. Um, but it seems like a lot of lawyers will list the general damages
Yeah.
and sometimes include mental distress
Yeah.
under that versus some will do the aggravated. So,
Yeah. So aggravated damages, think of aggravated damages as they are so if you think of general damages as like, okay, I've been injured, I've lost the ability to work. I know that I was working a job and that up until now I would have earned like $150,000 because that's my salary. We can calculate it. We don't know in the future would I've always worked at this job, would something else have happened, and da da da. So the part in the past is easier to calculate with precision. The future is unknown, so that would be the difference between like a special damage and a general damage. Aggravated damages are something else entirely. They are more they're meant to compensate you for kind of the stress and like mental distress basically that you go through because of whatever the action is. So
mhm,
aggravated damages would come in related to the mental distress caused by the situation. But it has to be you're being compensated because of stress or inconvenience that you've suffered. You see it mostly aggravated damages in contract cases. Normally, in like an injury type case, is going to be called a non-pecuniary damage. So that's where you're going to see that. Usually, you see aggravated damages. It's mostly you see that in contract type cases, whereas in a negligence type case where it would be like an injury claim, you'll see the idea of they call it non-pecuniary damages, which is a weird word, but
that that makes a lot of sense actually, because that's where I'm seeing a lot of it. They're
right,
calling it general and
yeah,
non, how do you say that word again?
non-pecuniary. Yeah.
Yeah.
Yeah. Yeah.
Yeah, that
So you
actually
got
makes a lot of
pecuniary,
sense.
which means like it can be calculated with precision. It's money. It's an amount that easily can be known. That's pecuniary. Non-pecuniary is something that is it's different even it's again I mean it falls under maybe the rubric of general damages. This is like a theoretical kind of legal talk, but if you're going to get into this stuff, but non pecuniary can be calculated, non-pecuniary can't be calculated, and it is in the injury claim world, these are going to be like pain and suffering is
Hmm.
what it is.
Yeah.
Pain and
Yeah.
suffering is not pecuniary, and then general damages are damages for a wide variety of things that just can't be calculated with precision. They fall under general damages.
Hmm. No, that makes sense. All right, we have another question over here. Um, how would the insurer be able to find out about the trips you took? Social media.
Social media, it'll be mentioned in your doctor's records. Other people tell them. You got like nosy neighbors who are just out to get you, an ex-spouse who hates you. So there's all kinds of ways that they can find out, but usually it's going to be social media or your doctor's records will mention it.
Hmm.
You don't want them finding out, like, you don't want them finding out because whenever they find out something, they get a rush of like a dopamine rush that they've now discovered a fraud. And it's like, finally, because they're used to being shit on all the time that you're terrible, there's this and that. So the first time they find something that looks like, okay, finally I'm justified. And like, you don't want to be that person where they feel like they've found out you were hiding something because they go hard.
The insurer has asked me if I have traveled.
Yeah, if they've asked you that, you definitely want to tell them. I recommend people get out ahead of it. Like if you're going on a vacation, I've had people book like book consultation calls with us, paid consultations for me to tell them that, even though I told the staff, just tell them you should tell, they still want to talk to me about it. But so I recommend you always get out ahead of it and tell the insurer that you're taking a vacation, whether you need to tell them or not. We got a whole process we recommend people go through, like getting it approved through your doctor, getting your doctor to write a note confirming that this will not interrupt your treatment and that'll be good for you. And then you give that all to the insurer. That way they can't like discover it. Because whenever they discover it, like I told you, they get like a dopamine rush. Not, I'm being kind of facetious here, but that is the idea. Like they are used to being like shit on all the time and sometimes deservedly, sometimes not. But once they feel like they've discovered a fraud or a potential fraud, then they get their backs up a lot. And if they believe that you're dishonest, forget it. Like they will fight, they will fight to the end. Most of these insurers. I've had cases where it's like it goes really bad. Yeah. Yep, it goes real bad if they think that you're a liar. Like they will forget it. Like you're going to fight till the end. That's why every book I write is so focused on maintaining your credibility because of how critical it is.
Hmm. Yeah, and I guess like it really isn't that big of a deal to go on a trip for a
No.
week, but if you end up lying about it, then you're
But
just
depends
making
on the trip,
yourself
right? Like if you're on a hiking trip,
true.
you're up at Machu Picchu, wherever it is there in Peru, wherever, and you've got a disability and you can't, then it's starting to get a little sus. So it depends on
Hmm.
the trip, but generally, like Maddie's saying, just a vacation is not a bad thing. Like it really isn't. The timing of it can just be bad luck.
Yeah,
So the timing can be a bad luck.
yeah.
So you just don't
Don't,
want to be going on vacations around the time you're stopping work. And I've had people like who legitimately had a vacation scheduled, and then this came up, and I told them, I know that this was been scheduled, everything else, I still think you should cancel it.
yeah,
But it's tough. People should be able to do a vacation.
yeah. You need a vacation probably more than most people need a
Right.
vacation too.
Exactly. And sometimes it can be beneficial. You
Yeah.
just have to be careful of the social media and of the insurer,
Hmm.
quote unquote, finding out later that you did it.
Yeah.
People will rat you
Don't
out,
don't be like
coworkers.
that client of yours posting crazy optical illusions, looking like you're doing all this
I mean, she
insane
didn't do
stuff.
anything wrong. I didn't give her a hard time for it because she did give me other photos afterwards that showed different angles, and I was like, oh, okay, yeah.
Yeah.
But yeah, they were really fixated on that
Hmm.
because she had a back issues. She, sitting, and it looked like she had climbed out onto this like cliff basically and was hanging her feet over it. Like it was insane. I was like, okay, yeah. If you've got that is not conducive to your disability. But then she's like, yeah, but look at this photo. I'm like, okay, yeah, right. Now I see.
Hmm.
But that's the perfect example of like, don't believe. There was a time, like I'm old enough, like I'm very old compared to some people, maybe not to everyone on this, but I remember when social media was new and there was a real problem because a lot of the judges, like judges are usually going to be older. Judges are usually going to be in their 50s and up, usually. Sometimes they're even younger. When social media came in, like all these at the time, they would now they're in the probably 70s and 80s now. But back at the time when social media started, these judges were old. They weren't on social media. They had no idea. So they all thought that whatever's on there is real. They didn't realize how people are phony on social media. There's filters, like it's the level of phoniness is like through the roof, but they would think it was all like real and this is what so there was a lot of cases where people were getting destroyed on social media. I
Yeah,
mean,
you don't even think about that, but that's probably so true.
oh
That
yeah,
you
like
just don't understand the context of everything.
yeah, I had a case where can't really get into a lot of details about it, but let's just say there was a case involving someone who made fake uh, personalities, let's just say, on social media to attract women, and had like resumes that were fake, like of accomplishments and all these things, and it became a real problem with the case because it was a long-term disability case when you have all these resumes of all these accomplishments and things you're doing at the time you're saying you're disabled and then you have to say this like the person was saying to me yeah but David everybody does that. I'm like no not really,
Maybe not.
not really, not everybody's doing that. Maybe a lot of people in certain circles and things, but no it wasn't but anyway, so that was a real problem with that case. But my argument was, how's a guy going to get a woman if you can't fake a few things here? Because he's in a hard spot, like he's not able to do everything. You gotta sometimes you gotta like put your best foot forward. That was basically my argument. I remember the insurers were like, they were just like, they weren't. It was two women on the other side. They weren't too pleased with the whole thing,
They
but
weren't having it.
they weren't having it. No, but
We we got another question over here on YouTube. Thanks again. It's just that there's been so much trauma in Canada and I rarely leave my house. But being in another country always makes me feel better. I just hate the optics. Yeah.
yeah, yep. I lost my Q&A. There it is. Okay, let's see what else they got. Trying to think of anything else interesting that's come up over since the last week.
We've been saying this forever, and I don't want to keep saying if it doesn't happen, but we are getting a website shortly. We're hoping it'll be done by
Yeah.
end of February, but no
Maddie, you're
promises
like
on
that
that.
deadbeat parent. You're turning into that deadbeat dad telling us, promising us you're going to take us to the fair. Come on.
I know. It's been taking forever, but it looks like we're getting to the end of it, and it's going to be really good, especially for everyone here. If you ever want to browse our learning center, it's going to be a
It'll be,
lot more user-friendly of a website.
yeah,
So
it will be a lot better.
more accessible, just everything will be better.
Absolutely. No, it's going to be a lot better.
Hmm.
Think of what I've had going on this week. That might be interesting. Been working on mostly employment stuff here lately. Mostly employment stuff. filed some interesting lawsuits. So we're interested to see how those go. I don't really want to talk about them too much, but a couple really interesting ones. And yeah, I guess I have to be careful what I say. Yeah.
You went to a conference, was it 2 weeks ago?
Yeah, I did. Yep. It was in Fredericton, New Brunswick. It was with a bunch of lawyers. Uh,
Hmm.
it was interesting. Yep. There was some different, it was kind of a conference where it doesn't cover a lot of legal areas that I do, but I mostly go just to talk to other lawyers, do things that I absolutely hate, which is like socializing with other lawyers and things. Nothing against the other lawyers. I don't like that scene. But I do have to do it, unfortunately. Just to other, you can't be a complete hermit. But it was interesting. Ran into some old friends. Uh, Talked to some other lawyers who are using AI. I'm using AI quite a bit now with a lot of the work I'm doing.
Hmm.
So I ran into another guy who's also testing the waters with that. It's
Yeah,
pretty
how are you finding the AI? Like, what do you normally use it
pretty.
for?
I use it for a lot of things. I've got into the habit now of just using it daily. So
Hmm.
it does a great job at analyzing things. So the AI we use is an AI that has been set up um, so that it's in a private environment. It's not just the Google, it's not just ChatGPT that's online. So there's AI that is, you pay a lot more for it, but it is on private servers and things. So it maintains confidentiality of information, but analyzing stuff with it is a huge,
Hmm.
huge time saver.
Yeah, it's taking over the world.
Yeah, instead of me like going reading through a document for certain basic information, you can get AI to help analyze things, and it's fast and it's pretty accurate. So doesn't do everything. It helps with writing things. It can help writing letters, um,
Hmm.
drafting documents. It's not earth shattering yet. So when you hear of things like, oh, the ChatGPT is passing the bar, like, yeah, it's good at answering questions and things like that, but it's not good at, it's still not even close to being able to do like
Yeah,
putting together legal analysis and this kind of stuff. It's good at like factual information, but not great at putting together like a real analysis and things and pulling in case law and
it
this.
did pass the bar though.
Oh yeah, yeah. It does that easily. But yeah, I can see how it would do that because it's the answers to the bar is available online. Like it's not even at
Yeah,
first when I heard it doing that, I was like, oh, it's not really that difficult because a lot of these questions on the bar, like it's generally legal principles that are available. So it would be quite easy for it to do that. It's hard,
yeah,
but what it wouldn't be able to do is like do like a novel situation where you had to like rely on statutes and case law and things like that. Now I think it's going to get there, but it's just not there yet.
yeah. No, that's cool though. All right, we have a couple more questions over here on YouTube. Just a comment. This is very informative. Thanks for everything you guys do. It's really much appreciated. Hi there, I'm on LTD, and there's a possibility that the company I work for may close up shop in Canada due to tariffs. Would this affect continuing, would this affect my continuing to receive LTD?
Probably not. Probably not. Probably your LTD is through a separate insurer, so it would have no bearing. Like it'd be no different if you were your employer laid you off while you're on disability or went out of business. This is more akin to like going out of business type of thing, but it should not have any effect as long as your LTD is paid through an insurance policy. If your LTD is not paid through an insurance policy, then it can get dicey, but it's unlikely that that's the case. It's more likely that you're being paid through an insurance policy and it will just continue on, even if the company leaves. That's unfortunate though.
Mhm.
Yeah, tariffs even affect us. We have a lot of things we pay for out of the US. So the tariffs hurt, even hurt a law firm like ours who really aren't, you wouldn't think of a law firm as being, you know, that tariffs would make a big difference, but it actually does if it affects the exchange rates and things like that. A lot of the software we use is all paid for in American money. Um,
Mhm.
so we'll have to see where things go.
Yeah, they're saying here it's through Manulife.
Yeah, it's likely. You have to be careful because sometimes Manulife and these other big insurers will just administer these plans on behalf of others, but I would expect that it's likely a insurance policy and that you're going to be fine. It's something you could ask the employer or even ask even ask Manulife. They would tell you.
Hmm.
You could ask something like that to them and they would be able to tell you right away. Okay. Well, we're coming up on our hour. We said it's the employment disability claims hour. Sometimes we go over an hour. Sometimes we go way over an hour, but
Sometimes we go a little under, just
yep,
depends on the day.
on the day. Well, folks, we'll see you next week. What are we doing next week, Maddie?
I always forget to check this right away, but I'll check it right now. All right, there we go. Oh, this one's interesting. So, dating in the workplace, um, do's and don'ts. So, if anyone is experiencing that, wants a little more information, it's also just an interesting topic. So, feel
Yep.
free to come and you can ask any question, doesn't have to do with that topic. And yeah,
All right. We'll see everyone. Take care, Maddie. I'll see you tomorrow and I'll see the rest of you guys here next week. Take care.